The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have 3 cases that will be submitted this morning. Those cases are Wilma Kellogg versus City of Albia, Mark Griffion and others versus Cedar Rapids and Iowa City Railway Company and others. And the final case is in the interest of LH. That last case is now submitted to the court without an argument, and we'll proceed to hear the arguments in Kellogg. Mr. Priebe. All right. I'm sorry, Ms. Crane, you may proceed.
Good morning. May it please the court, opposing counsel. My name is Sarah Crane, and I'm here representing the city of Albia in this matter. This case is before the court on an application for further review. The case involves the plaintiff's complaints against the city of Albia from flooding or water seepage in her basement, allegedly caused by a storm drain that was constructed in 1972. The district court granted summary judgment on 2 grounds: the state-of-the-art defense, which is a statutory immunity codified in the Municipal Tort Claims Act, and the statute of limitations, also found in Municipal Tort Claims Act. The Court of Appeals reversed in part and allowed the plaintiff to proceed on a nuisance claim for temporary damages stemming only from the 2 years prior to when she filed suit. We are on application for further review today, urging the court to reverse the Court of Appeals on both of those grounds and affirm the summary judgment grant in full. Beginning with the state-of-the-art defense, this is found in Iowa Code section 670.41H. The statutory language is really the guidepost for this court's decision-making here. It applies to any claim based upon or arising out of negligent design or specification. It also applies to any claim for a failure to upgrade, improve, or alter any aspect of an existing public improvement to new, changed, or altered design standards. The Court of Appeals correctly held that a nuisance claim can be barred by this state-of-the-art defense. And the real question is kind of where to draw the line and whether a nuisance claim falls within this language.
You know, what if someone built, let's say, a garbage dump to all the design standards and everything else, but it still emitted odors and caused vermin to come and all other things? It's not based on negligent design. It's based on operating the facility, which creates a nuisance, which is really, the damage is a property right. It's an easement, and payment for that easement to use your land by spreading noxious materials on it. I mean, why would this have anything to do with it if we're talking about damages for an easement to, and it's clear it was up to standards, but it's being operated and it causes a noxious condition.
The question there would be what the basis of the plaintiff's claim is. So in that hypothetical, the plaintiff's claim would be based on operational decisions that are being made, sort of ongoing decision-making in the operation of the dump, as opposed to a claim that's really based on...
Not really. There's some things that are just nuisances that you can't operate without being a nuisance. I mean, go move next to the packing plant on the east side here. They could do everything they want. I still smell in the morning when I come to work.
Again, I think it comes back to the statutory language and what the basis of the plaintiff's claim is. The legislature has already made that determination that if the claim is based on a need to upgrade the design standards to current standards or a negligent design, that there's immunity for the municipality.
It seems to me you're kind of swimming upstream, so to speak, with the negligent design argument when we're talking about a nuisance claim. Isn't your better argument based on the last sentence, the one that says, a claim shall not be allowed for failure to upgrade, improve, or alter any aspect of an existing public improvement or other public facility to new, changed, or altered design standards? Isn't that really what we're talking about? You had a sewer system. It was adequate at the time. Not uncommon situation. There's more development. It's no longer adequate. Now there's a lawsuit. Is that
Yes, I would agree with
Correct.
that, and I think that's consistent with the facts of this case. This case, the plaintiff submitted an expert report in support of resistance to summary judgment, and the plaintiff's expert suggested that it should be brought from a 2-year storm interval to a 5-year storm interval, and that it needed to be brought to current standards. So you could possibly have a different case that involved a failure to maintain or repair a system to its original 1972 standards, but that's not the case we have. We have here an allegation that the 1972 system needs to be brought to more current standards. And that's where the Court of Appeals standard basically expands what would become an exception to this statutory immunity that could essentially swallow the rule. Almost all negligence claims could also be pled as a nuisance claim and create an end run around the statutory defense.
Yeah, but the damages for nuisance are different from the damages for negligence.
That sort of wades into this question of the permanent versus temporary nuisance, and whether you're allowed to seek damages for the change in the value to the property versus a temporary nuisance where it would be the damages based on damage during a time frame. And that's the second ground on which we're urging this court to reverse the district court, the statute of limitations.
Well, before we get into that, let's stick with the nuisance issue just for a moment. If you look at the picture of this drain pipe, and it sticks right out of the ground, pointed right into the basement of this home, and and it was built under the current design standards at the time. Let's say that there's just become so much development in the area that every time it rains, the water comes pouring out of that and floods the basement. Would that evolve into a nuisance claim if it happened every time it rained? Let's say every time we got more than 1 inch of rain. Would that be a nuisance?
Well, we don't dispute that the plaintiff has brought a nuisance claim for purposes of summary judgment. So for purposes of summary judgment, a nuisance claim lies. However, in that circumstance, the legislature has determined that municipalities are not liable in tort for a failure to upgrade. And so to the extent the plaintiff's claim would be
did they
that,
say tort?
yes, yes, under the Municipal Tort Claims Act, but they define tort to include nuisance. So the definition of tort in the Municipal Tort Claims Act includes nuisances.
But does the immunity statute apply to, isn't the whole purpose of the immunity statute is that you're immune from any claims that you need to upgrade your system?
Yes, that's correct. And so
Can something still be a nuisance if it's just gotten so bad that it's just a constant problem?
It could still be a nuisance, but the legislature has made a determination that municipalities should not be liable in tort for that nuisance.
But if you take the chief's example, and it's flooding all the time, then you're talking about maybe a taking. Because if they're going to continue to use this person's property for their excess sewer capacity rather than take care of it, you're going to end up with inverse condemnation and a taking, which is, again, a property interest, not a tort interest. And that's what nuisance is. It's the short of the taking, the total taking. It's a partial taking, and you get compensated for the partial taking.
It may be that a plaintiff could have an inverse condemnation claim where they were not allowed to pursue their nuisance claim. That would most likely be barred by the statute of limitations in this particular case, which would be very similar to the K&W Electric case. But if in that circumstance, an inverse condemnation case would be a different legal theory. But the state of the art defense does apply to nuisance claims, which is what we have here.
Your argument would be that, an inverse condemnation case can't be there because the taking was based upon a negligent design, and it was designed properly at the time, and the legislature immunized an inverse condemnation.
Well, I think an inverse condemnation claim would be distinguishable because, the court has explained with this state-of-the-art defense that the extent of the public agency's duty for purposes of establishing non-constitutional torts is measured by the generally recognized engineering or safety standard, criteria, or design theory in existence at the time or construction or reconstruction. So an inverse condemnation theory would have its grounding in constitutional claim. and would most likely be a separate
So if
analysis.
they brought a inverse condemnation claim based on a partial taking, that's whenever it rained, because if you've ever done eminent domain law, they always have, you know, they usually have a partial and a full taking. They have a partial taking where they may use part of the property to stage what they're doing, and then they have a total taking on the property they're actually building the road on. So if this was framed in an inverse condemnation claim, the next time it floods, it seems to be semantics over, you know, getting to the problem, which is using these people's property as an easement.
It's not semantics. I mean, it's legal theories matter, and the legislature has carved out an immunity for municipalities for claims such as
Is
this
it your
one.
position that the immunity includes a pure nuisance claim, that that's immune as well?
Yes, because the second part of this statutory language applies to a claim under this chapter shall not be allowed for failure to upgrade, improve, or alter. It doesn't back to the negligent concept. And so there is kind of the older case law from before this statutory section was enacted that distinguished between negligence and nuisance claims, but that's not the standard for this court.
Well, if the claim is not that you're failing to upgrade, but if the claim is that it's just inherently dangerous, it has gotten to the point where it's become inherently dangerous, is that immune?
The inherently dangerous concept is, it's not the legal standard for this case. The inherently dangerous question comes from case law determining whether a nuisance claim exists. And for purposes of summary judgment, we've agreed that the plaintiff has a nuisance claim. It may be that we have summary judgment grounds on whether or not this is inherently dangerous on remand if this were to go back to the district court. The question has to turn to the statutory language of what the basis of the plaintiff's claim is. So regardless of whether it's a nuisance, whether it's considered inherently dangerous, it depends on whether the basis of the claim is that an original design standard needs to be upgraded to current standards.
But a nuisance basically creates its payment for the easement, and they're not required to upgrade it. What they're required to do is every time that they foul up the basement, they have to pay for the easement to do it. No one's requiring them to update it. I mean, you can get nuisance damages without requiring to update it. The hoglot cases, you know, they didn't update the hoglot cases. The court ended up writing a nuisance after the verdicts, giving them an easement to foul the neighbor's land. And that took care of it. So basically, if this is an easement damage, no one's asking them to upgrade it. I mean, on a negligence case, they might. But if they're going to keep creating this easement and going across in these people's basement, they don't have to upgrade it to prevent the nuisance. They're just going to have to pay every time they use they create the nuisance.
Well, the basis of the claim is still that because the system hasn't been upgraded, it's causing the damage. It's not a situation where there's an ongoing action or a failure to repair or maintain it to that 1972 standard that's causing the injury. So the statutory immunity would still apply. The hoglot cases were private parties that didn't involve a municipality with this statutory immunity.
I'd like to come back in the same line of argument. If the claim is it's fine, yeah, 1972 standards, fine. You don't have to change it. Go ahead and operate it. But when it rains heavily and encroaches on my property and floods the basement, you simply have to pay for that as kind of a cost of doing business. Keep the culvert there. Don't change it. It's fine, except when my basement floods, and then it's a permit to operate according to 1972 standards.
The legislature's disagreed with that. The legislature has entered an immunity where the municipalities do not have to pay for that because they're immune from that tort claim.
But isn't that immunity, though, confined to claims based upon negligence? And it's as though, it seems to me that your position asks us to conclude that the nuisance theory is just masquerading. It's a negligence theory masquerading as a nuisance claim. But I think the questions that are coming from the court are asking you to address this distinction between nuisance, which is not mentioned in the state-of-the-art immunity defense, and negligence. Now, he's pled both of those theories, but they are distinct, and you've acknowledged they're distinct. So are you really asking us to conclude that his nuisance theory really isn't a nuisance theory? It's a negligence claim masquerading as a nuisance theory?
We're not, because the code section contains two parts. It applies to any claim for failure to upgrade, improve, or alter. So it does not require it to be masquerading as a negligence claim. This section, because tort in the Municipal Tort Claims Act is defined to include nuisance, the reference to any claim includes a reference to nuisance claims. Therefore, nuisance claims that fit within this statutory language are also barred whether or not they sound in negligence. Now, if they sound in negligence, they are also barred if they sound in negligent design. And that's distinguishable. The prior case law distinguishing between negligence and nuisance is not based on the statutory language, but it is interesting because there is a distinction between an ongoing operational decision, such as the sewage cases, which is the Ryan versus Emmitsburg, Hollenbeck vote, where there was kind of an ongoing decision to dump sewage in a river or fail to sanitize the sewage, as opposed to a permanent structure that needed to be upgraded to different standards. I see that I am out of time, and I will turn it over to counsel. Thank you.
Ms. Crane, thank you. All right, Mr. Priebe.
Thank you. I'm Zach Priebe on behalf of the plaintiff appellant, Wilma Kellogg. May it please the court and counsel, Ms. Crane. Obviously, today we're asking that this court affirm the decision of the Court of Appeals. I want to make one thing clear, first of all. We've conceded that the city is immune from liability as far as any negligence claim is concerned. Conceded that at the Court of Appeals. I think additionally we indicated to the Court of Appeals that the expert report that we provided is no longer part of our claim. I think the city is wanting this court to read into the statute nuisance, or excuse me, negligence, where our claim is only nuisance. Our claim's not based on lack of standard of care in operating or designing the storm sewer. It's based on the creation of the condition on the Kellogg's property.
And tell me about the evidence to support that claim. Is it just that it's flooded 8 times since 2009? Is that the evidence to support nuisance?
That's essentially the evidence, yes. But also, there is evidence that there's inherent danger in that flooding. Ms. Kellogg, as I recollect, and in her depositions that are part of this, are part of our appendix, she indicated, and it's on page 26 of her deposition, but that there is flooding near electrical appliances. There's also mold developing on the walls inside the home. That's where we get the inherent danger. Mr. Glenn, Ed Glenn, he lives with her on the property. He indicated that the house is sinking. They had to anchor walls. And again, we think that's part of the inherent danger, part of the evidence that supports the fact that we've created a dangerous condition on the property.
I mean, I don't think there's an issue that there's a problem here. The question is who pays for the problem, or whose responsibility it is to pay for the problem. And aren't the facts that this storm sewer was constructed in 1972, and then this house wasn't even built until, and you're not disputing that the storm sewer was adequate at the time for what it needed to do in the city, correct?
That's correct, Your Honor.
All right, and then this house comes along in 1983, is built then, right?
That's correct.
And your client buys it in 2008, is that right?
That's correct.
So am I misreading the statute that the legislature has kind of made a policy judgment that if a municipality builds some kind of infrastructure thing like this that's adequate at the time, and then people come along afterwards and there's more development, it's not, you don't have a tort claim against the municipality over the adequacy of the infrastructure? Isn't that the judgment the legislature made?
I think that they limit immunity to negligence claims, Your Honor. And what I tried to do in our briefing materials, and I think it's the Martin's case that we cited, negligence doesn't have to come along with nuisance.
Well, yes, but I'm going to challenge you. I understand the negligence issue, but you've got the second prong of the statute, if you will. A claim under this statute, a claim, and claim includes nuisance. The claim under this statute shall not be allowed for failure to upgrade, improve, and alter. Isn't that a standalone provision? It just says a claim shall not, under this chapter, ... Whether it's negligent or whether it's strict liability or whether it's an intentional, well, maybe intentional tort might not work, but a claim under this chapter, a claim, shall not be allowed for ... Isn't that an independent requirement?
It would seem to be, Your Honor, but as far as the arising out of language is concerned, I know that's broadly interpreted. It's talked about in the Cubitt versus Mahaska County case. And even though there's the broad interpretation, there is required the causal.
You may be out of that. I mean, I'm going to concede that for purposes of our discussion here. You may be out of that, but you still arguably land in what we're kind of referring to as a second prong, which is not limited to a negligence claim on its face, I don't think, although I encourage you to push back. The history of the case, if I have it correctly, is, you know, your client contacted the city and wanted an upgrade and change and do something about this. It didn't happen. So I'm asking a number of questions, but I want to focus on the second prong. Number one, it doesn't have to be negligence. Number two, isn't the nub of your claim actually they got to upgrade the thing?
I'll answer the second part first. I think certainly the petition that was filed back in 2015 asks for an abatement of the nuisance. Now, does that necessarily require that the city makes some alteration or change to the storm sewer? I don't believe so. And I would cite to the defendant's own expert's report for support for that proposition, and their own expert's report, and I believe that it's certainly part of the appendix, but they first of all, the city has, throughout the course of this case, maintained that the sewer is designed and operated perfectly. Nothing wrong with it whatsoever. The defendant's expert's report references a grading event that the city completed near their property, and that we believe that's part of our claim, and that was in 2014. That's in the defense expert's report. So I think for purposes of summary judgment, I don't know that we can say that a fact issue does not exist here based.
So you're saying a grading remedy would not be an upgrade or an improvement or an alteration?
Not to the sewer, because I think the grading was done in the alley next to the house, or at least right next to the property. Had nothing to do with improving or altering the storm sewer.
Let me ask a question. You know, one of the things you want is to abate the nuisance, but some nuisances aren't abatable. You can't abate them, and then the measure of damages become the loss of value. I mean, that has nothing to do with requiring them to upgrade the sewer system. I mean, what do you want from this city?
If the city wants to pay for an easement, I think that would be an item of damage also, if we took this to a jury trial.
If the statute says they don't have to upgrade it, then it becomes an unabatable nuisance, and then you're left with the easement damage, aren't you?
Yes, I agree with that, Your Honor.
Did you make a claim for inverse condemnation or eminent domain or a taking or any constitutional claim?
No, Your Honor, that was not part of the petition filed in this case.
Was there any claim that there were cracks in the storm sewer due to a failure to maintain or repair it?
Try to answer that as best I can, Your Honor. I wasn't counsel for the Kellogg's at the district court level. That may have been part of the expert's report, the plaintiff's expert report at the district court level. Again, though, we concede that negligence is not part of this, and we are not pointing to our expert's report in any way, shape, or form.
Is the reason there's flooding that this storm sewer isn't big enough? It lacks the capacity, although it was right-sized in 1972 due to subsequent development. A larger diameter would be required to avoid the flooding.
That's true, Your Honor. And although I think if you read the defense expert's report, I think that would indicate that it works perfectly well, and these flooding events are beyond what it was designed for, I guess.
Well, isn't the need for a larger capacity, isn't that a claim based on a failure to upgrade?
It certainly, it sounds like it, Your Honor, but our claim is based on the condition, the dangerous condition created on the property. We're not saying necessarily that they have to change the sewer in any way. We'd rather have them abate the nuisance or focus on the condition created on the property, Your Honor.
But what does the record disclose as far as the city's failure to repair, maintain, or operate the sewer system or the drainage system? Because that, to me, is the crux of any type of nuisance claim, is that they haven't repaired, maintained, or otherwise operated the storm sewer such that it creates a dangerous condition. I mean, what haven't they done that would create the liability for them for this nuisance?
Well, and that's why I point to the defense expert's report, Your Honor. I don't think their actions or inactions are limited to maintaining the sewer. Obviously, they've done some grading around that property, and if that is the cause of the condition, then I think that is its own separate claim.
But did you plead that? I mean, I haven't really, this is really the first I've heard of it, and I haven't gone through all the reports and all the record in this, but this is the first I've heard about any allegation that something that the grading is concerned, and I didn't see anything in the Court of Appeals opinion or frankly in the district court's decision either.
Well, and I guess that brings up a good point, Your Honor. The focus of the district court was solely on the negligence issue, the negligent design failing to alter or upgrade the storm sewer. Whereas I don't know that really the issue of negligence, or not negligence, excuse me, nuisance was taken up in the summary judgment ruling, Your Honor.
So I think I agree with that to a certain extent. The Court of Appeals obviously did, though, and they concentrated on the nuisance. I think we all agree that the nuisance can be subject to the liability or the immunity from liability, and you would agree with that as well. It sounds to me like they didn't really find any fault with the repair, maintenance, or operation of the storm sewer, but concentrated solely on this inherent, I guess we're referring to it as inherent dangerousness of the conditions that resulted from it. Is that fair?
That's fair. But I would like to say, and I've tried to make this clear throughout, but sometimes I don't express myself perfectly clear. I would submit that in order for nuisance immunity to attach to 670.4 subsection H, that nuisance needs to accompany negligence. And that's why I've cited to the Martin's case, which stands for the proposition essentially that nuisance can accompany negligence, but it doesn't always have to accompany negligence. And again, we do not have a negligence claim here. We concede that point. Do you want to discuss the statute of limitations issue? Again, we agree that, or we agree with the appellate court ruling that our claim is limited to the 2 years prior to the filing of the petition in February of 2015. However, these flooding events are intermittent events. Again, we're relying on Hecht versus Hawkeye Tri-County 1994 case. And that basically indicates that the intermittent damage gives rise to a new cause of action each time it happens. There was no permanent damage, such as in the K&W case with the inverse condemnation.
Mr. Priebe, let me direct you back to the nuisance issue. You identified mold and the danger from water being around electrical appliances and some sinking of the foundation of the home as some inherently dangerous conditions. But the element of nuisance requires that the nuisance be caused by an inherently dangerous condition. What's inherently dangerous in this pipe running from under the street and sticking out from the other side of the street? What's inherently dangerous about the pipe?
Well, we're not sure that it's entirely the pipe, given the defense expert's report. But I look at inherent danger as what's created on the property, what is the condition created on the property, what's the danger to the property owner. And obviously the flooding near electrical appliances in the basement, the mold, the anchored walls that have been required, that's the inherent danger as far as the plaintiff is concerned, Your Honor.
All right, thank you, counsel.
Thank you, Your Honor.
Ms. Crane.
Thank you, Your Honor. I'd first like to briefly touch on our expert report. Our expert report concluded that the 2014 modification of the grading in the alley near the northwest corner of 321 4th Avenue had no negative impact on the drainage. So our expert report sort of mentioned the grading and said it had no negative impact. There's no expert report from the plaintiffs suggesting that's the cause. The plaintiff's expert report focused on the need to upgrade to current standards, and the plaintiffs have now disavowed that expert report on appeal.
Ms. Crane, could you direct me to the language in 670 .4(1)H that immunizes a claim for pure nuisance?
Yes, the reference to any claim, it's our position that any claim must include claims for nuisance. And the reason is because the Municipal Tort Claims Act, when read as a whole, defines tort to include nuisance. And therefore, the reference to any claim would include nuisance claims.
Well, I understand that the legislature has defined a tort to include a nuisance, but when you dig down into subsection H, it says any claim based upon or rising out of a claim for negligent design, et cetera, et cetera. It doesn't specify nuisance as one of the claims that covered under subsection H, does it?
Well, it doesn't break down the potential, the variety of potential claims, theories that could fall within this section, but it would apply to any claim that's based upon or arising out of negligent design, or any claim that that's allowed for failure to upgrade, improve, or alter.
Aren't you better off under the following sentence, as I think Justice Apple and I have suggested, where it says, a claim under this chapter shall not be allowed for failure to upgrade?
Yes, I think we probably, that's a stronger argument, although we also believe that we would fall under the based upon or arising out of language.
What about the first provision under 670.41 where it says that liability imposed shall have no application to any claim enumerated under this section? Does that tell us what sort of claims we're talking about here? Don't they have to be enumerated under 670.4?
Well, the nuisance is enumerated in the definition of a tort, and this falls under the Municipal Tort Claims Act. And so when the statute's read as a whole, any claim would include a nuisance claim. I'd like to also briefly touch on the statute of limitations. There was a question
Before you get off on that, let me ask you this question. Did you just does that argument then render superfluous all the first sentence or two in subsection H? Why didn't the legislature just use the last sentence then? Any claim under this chapter for failure to upgrade is immune.
I think the
Why
legislature...
did they go through and specifically define negligent design, negligent adoption of a design, negligent construction? They went and defined all of these claims for negligence, and then you're claiming that the final sentence that a claim under this section shall not be allowed.
Mm-hmm.
Why did the legislature take pain to describe specific claims if they just meant to include every claim?
Well, I don't think either one of these is describing specific claims as opposed to kind of what's the basis of the claim. And I would suggest that the legislature was trying to be clear that it does not want municipalities to be liable in tort for any claims relating to the original designs when those designs are up to the state of the art at the time they're constructed. And that's consistent with the way the court has explained this immunity as limiting the extent of the public agency's duty.
I guess just to interrupt, isn't that part of the definition of 670.14, which talks specifically about a tort claim and talks specifically about nuisance? Doesn't it say nuisance in there?
Yes, and that's our position, that when you read the municipal tort claims as a whole, nuisance is included as a type of claim under this statutory chapter, and therefore the immunity has to be read to apply to nuisance claims.
I guess I don't want to split hairs, but negligent design and state-of-the-art are kind of two different things. In other words, the first sentence may bar negligent design, but you could have something that conformed to the state-of-the-art that didn't conform to the state-of-the-art, was negligently designed. That would be one separate thing, and then you could have something that conformed to the state-of-the-art. So it does seem to me perhaps the two sentences serve different functions. Mm-hmm. Is that your view?
Yes, I think a strong argument can be made for that.
Just cost myself $2.
You may sum up.
Really briefly in wrapping up, I'd just like to make a point about, there's a question about whether some nuisances aren't abatable. Those are permanent nuisances, and the 2-year statute of limitations would bar a claim based on a permanent nuisance. So even if you were in that camp, this claim would be barred on the statute of limitations. Thank you.
Ms. Crane, thank you as well. The case of Kellogg versus City of Albia is now then submitted.